Hello everyone. I guess you can hear me and let's begin. This is the fourth video in the series of legal reasoning basic to advanced. In the last three videos, we basically discussed the paper of legal reasoning from CLAT 2020. The belief that we have instilled in ourselves is that with little or no knowledge of uh, legal avenue or law in general, we can ace this section, we can ace this paper in terms of legal reasoning. We have instilled this belief, and we are of the opinion that without any sort of what I would like to call legal knowledge, or without any sort of hard, rigid preparation in terms of memorizing law, we can ace this section and we can do really, really well. So we'll follow what we have done in the past three videos. We'll start with our paper of 2021. We'll relate all the we'll relate all the learnings that we have had, how the paper has worked, and what were the questions that were asked to us. So without wasting any more time, let's jump into it. There is the first passage, and let's start. Harm suffered voluntarily does not constitute a legal injury and is not actionable. Fair. This principle is embodied in the maxim voluntas non fit injuria. A person cannot complain of the harm to the chances of which he exposed himself with free consent and free will. So this seems like a principle that might help us solve questions. Sorry for the delay. So I'm back. Uh, so this seems like a principle that would help us solve questions further. Let's move ahead. The maxim voluntas non fit injuria is founded on good sense and justice. A person who has invited or assented to an act being done towards him cannot, when he suffers from it, complain of it as wrong. The maxim presupposes a tortious act by the defendant. The maxim applies in the first place to intentional acts which would otherwise be tortious. There are certain limitations to the application of this maxim. So, in this first paragraph of the passage, we have understood the very fact that there is a maxim named as voluntas non fit injuria. Beforehand, we were unaware of what did it mean, but now that the passage has explained us, voluntas non fit injuria means that a person who has consented or assented to to exposing himself or herself to some sort of harm by his free will, they, when suffer from such harm, cannot say that it was not their fault. Fair. Let's move ahead. Let's see what are the limitations to application of this maxim. It is no answer to a claim made by a workman against his employer for injury caused through a breach by the employer of a duty imposed upon him by a statute, but where the negligence or breach of statutory duty is on part of an employee of the plaintiff who knowingly accepts the risk flowing from such breach, and the employer defendant is not guilty of negligence or breach of statutory duty, the defense of voluntas non fit injuria is available to the defendant. So it talks about a condition of an employee and an employer. So if the employee and the employer are working in an area or are dealing with a business that contains or that involves harmful activities that might cause harm, if the employer is negligent, even though the employee has consented to such particular type of harm, he cannot be negligent in his duty to protect them, and if he has been negligent, he cannot claim the defense of voluntary non-fit injuria. Whereas on the other hand, if the employer has been cautious of all his duties and all his obligations, then he can avail the benefit of voluntary non-fit injuria. Under an exigency caused by the defendant's wrongful misconduct, consciously and deliberately faced a risk, even of death, when the person endangered is one to whom he owes a duty of protection as a member of family or as a mere stranger to whom he owes no such special duty. The rescuer will not be deprived of his remedy merely because the risk which runs is not the same as run by the person whom he rescues. But where there is no need to take any risk, the person suffering from harm in doing so cannot recover. So, in a condition where you are risking yourself for somebody else and such risk is necessary, you have the defense of voluntary non-fit injuria. But when there is no imminent risk, when there is no imminent danger involved, and yet you are risking yourself or you are taking a risk, the other person, the person suffering harm, cannot recover anything. To cover a case of negligence, the defense on the basis of the maxim must be based on implied agreement, whether amounting to contract or not. The defense is available only when the plaintiff, freely and voluntarily, with full knowledge of the nature and extent of the risk, impliedly agree to incur it and to waive any claim for injury. But when the plaintiff has no choice, or when the notice is given at a stage when it is beyond the ability of the plaintiff to make a choice, there can be no implied agreement, and the defense on the basis of maxim must fail. So here we are talking about the knowledge of the risk that was involved. Here we are talking about how the injury that the plaintiff had consented to, was he aware of its power? Was he aware of the damage it would cause? If no, then such defense cannot be taken. If yes, surely. The maxim will also not apply when the act relied upon is done because of the psychological condition which the defendant's breach of duty had induced. Fairly simple. So let's move and understand the questions that we are looking towards. In this passage, we talked about first the maxim of voluntary non-fit injuria. The maxim voluntary non-fit injuria basically talks about somebody who consents to a harm, who consents willingly to a harm, cannot then escape or ask the defendant to compensate for the injury that has been caused to him. Then we looked at certain conditions of an employer-employee conditions where the entire scenario was not known to the individual that consented. Let's move to the questions and make our way through them. Mr. A was the owner of a car and he had a driver, Mr. D. On such and such date, Mr. A and Mr. D were traveling in their car, wherein Mr. A got down at a restaurant and told Mr. D to take the car back to Mr. A's bunk. Mr. D was filling the petrol tank of the car and two strangers, B and C, took a lift from Mr. D in his car. The car went ahead and the right side front wheel of the car flew away. The car toppled and Mr. D and Mr. C were thrown out Mr. C sustained severe injuries and ultimately died due to those injuries on January 20. Mr. B and the legal representative of Mr. C claimed compensation from Mr. A and Mr. D. So in this case, there are four people involved: A, B, C, and D. A is the owner of the car, D is the driver of the car, and B and C are the strangers who asked to travel in the car. Now, when you're traveling in a car, you are aware of the very fact that there might be a situation when the car might meet an accident or the car might get into an accident and cause injury. After taking into account all these factors, it is only when you have understood that the car might or might not get into an accident, you sit into it and travel into it, which states that you're consciously aware of such harm. So Mr. D will be liable to pay the compensation? No. Voluntary non-fit injuria will be applicable and no compensation can be claimed. Fair, seems as a good answer. Will not be applicable and compensation will not be claimed? No. A and B will both be liable to pay. So in this particular scenario, what has happened is that the individual Mr. B and Mr. C, the individuals Mr. B and Mr. C, have agreed to sit in the car, and it is through their act, which was of sitting in the car voluntarily or through their own consent and through their own mind. It was through that act that they decided that they are agreeing to such risks, and through this agreement, we can tell that the owner of the car and the driver will have a defense in terms of voluntary non-fit injuria. Rama was a spectator at a motor car race being held on a track owned by the defendant company. During the race, there was a collision between two cars. One of the cars was thrown among the spectators, thereby injuring Rama severely. Which of the following statement is correct? Now, when you are going to watch a motor car event, there is a probability that the car might run upon you if it loses control. I'm not saying that there is a surety that it might run upon you, but yeah, there is a high probability that it might run upon you or might run into the audience if it loses control. So, as a reasonable, prudent person, as a reasonable man, I think that anyone would have it in mind while going to be a spectator to such races that if the car gets out of control, it might severely injure or even take life of the spectators. Rama impliedly took the risk of such injury, the danger being inherent in the sport, which any spectator could foresee. The defendant was not liable. Fair? It was a negligence on the part of the defendant? No. Rama did not take the risk of such injury, only consented to watching the race. No. When you consent to an activity, you consent to the idea of the risks involved in it too. It's not that you can consent to the good part and leave away the bad part. That doesn't work. So Rama was negligent, hence he suffered injuries. It is a vague option. We'll take option A and move ahead. But does that mean you agree to driving a car at 140 kilometers per hour? No, you don't. Fair. Knowledge of risk does not precede consent, but knowledge of risk must precede consent, obviously, because if you have consented and it is after your consent that you realize, oh, these are the certain risks involved, these are the certain risks that are inherent to this activity, that would basically be unjust. Knowledge of risk always amounts to consent? No. Mere perception of existence of danger amounts to consent. It is same as option C, but when we look at option C and when we compare it to option D is a lighter version or a more liberal version. So the only correct statement here is option A. Knowledge of risk does not always amount to consent. Fair. Lily had placed spring guns and wood on her ground for protection of the garden. Karan, with full knowledge that there were spring guns somewhere in the wood, trespassed on the land of Lily and was injured. Which of the following statements is correct? Lily will be liable to pay compensation to Karan. Lily has not committed a tort against Karan by exceeding her right of private defense. Karan's case does not fall within voluntary non-fit injuria. False. Karan had no knowledge of spring guns. Karan had the knowledge of spring guns and willfully courted the danger himself. Fair. So, what will we say? Will we say that Lily will be liable? No, she won't be because Karan had full knowledge. Will we say that Lily has not committed a tort against Karan by exceeding a right of private defense? Were we taught about private defense? No, we weren't. Is this not a case of voluntary non-fit injuria? It is. So with negation, we are left with only one option, which is option D. Let's mark it correct and move ahead. Which of the following is not an element to claim the defense of voluntary non-fit injuria? Fair. Prior knowledge of plaintiff about risk involved. Free consent. Plaintiff is compelled to agree to a risk by the defendant. Voluntary acceptance of the risk by the plaintiff. There must be free consent. There must be prior knowledge. The consent or the acceptance must be voluntary by the plaintiff. Nobody can force you into it. And again, by negation, reach to option C as the right option. Let's move ahead. We are finished with one passage and let's move to the other passage now. It is essential to the creation of a contract that both parties should agree to the same thing in the same sense. Fair. So here we are being told about an essential which is agreeing on the same thing in the same sense. Which means when I talk about a soap and in my mind I have a soap that is named A, and when you listen that I am selling a soap and we are about to come in a contract, you understand that I am selling soap B and we come into a contract. It does not stand tall or true in this. I, when talking about soap, was thinking about A, and when you were talking about soap, you were thinking about B. Both these things do not relate to each other. Let's move ahead. Which should also be one of a valid agreement. And one of its essential elements is that thing is understood in the same sense by parties as is understood. Now we have which is free consent, which is a sine qua non, which means that it is. Let's move ahead. Not only consent but free consent is provided under Section 10 of the Indian Contracts Act. It means that the consent should be free. It should not be what I would like to say influenced or something that has been done through manipulation. That is what we're talking about here. Fair. Consent is free when it works without obstacles to impede its existence. No consent or no real and certain object of consent. There can be no contract at all. Where there is consent is generally a contract free. Fair. It gives us another we would like to call essential happen if the consent was not freely obtained and it is necessary to such as fraud, which includes active concealment declared as fraudulent. In fact should have been done by the party to the contract or by any other person with his connivance is aid. So here we have been provided a descriptive idea of what a fraud, what would be called. There is no duty upon parties to speak about facts likely to affect the other party's consent. There is no duty upon parties to speak about facts likely to affect the other party's consent to the contract, and mere silence does not amount to fraud unless is in itself equivalent to speech. Fair. Now, the idea that is presented by this part of the passage is that there might be times when you are selling a particular good to someone, and the good might have some defects. Those defects, fair. The In such a scenario, what would happen is that these, what I would like to call goods, or these acts of selling goods without, what I would say, a particular description, would then amount to fraud, because now your silence is equivalent to speech. On the other hand, misrepresentation falls into three categories: a statement of fact, which if false would be misrepresentation if the maker believes it to be true, but which is not possessed or substantiated by the information he holds. Any breach of duty which gains an advantage of the person committing it by misleading another to his prejudice, there being no intention to deceive, and causing a party to an agreement to make a mistake as to substance of the thing, as to the substance of the agreement. Fair. So this particular passage we talked about contracts, how in a contract we must agree upon same things in same sense. If we talk about soaps, we both must have an understanding that we are talking about a particular kind of soap. And then when we talk about consent, the consent must be completely free. Fair. Then we talked about misrepresentation and fraud. Now, what is fraud? Fraud is basically an idea or a type of connivance where you deceive somebody knowing and stating something that you know to be false, whereas misrepresentation, on the other hand, is telling someone something knowing it to be true but having no proofs to substantiate it. Which of the following statements correctly depicts the essentials of misrepresentation? A misrepresentation is a positive statement of fact which is made or adopted by a party to a contract. 1872 reads as follows: communication when complete. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Fair, basic statement. The communication of acceptance is complete as against the proposer. A proposer is somebody who proposes. A proposer is somebody, let's consider a person A who wants to sell his car. So he goes to person B and states that I have this particular car that I want to sell. So A here is the proposer. When it is put in course of transmission to him, has to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposer. A very simple principle, but might trouble you. The principle is that there are two people. There is a proposer who proposes a contract, who proposes a deal. There is an acceptor to whom the deal is proposed and who might or might not accept it. So when the acceptor accepts the deal, and let's consider they are communicating through letters, and posts the letter stating that I've accepted the deal. Once the letter is posted, the person who proposed the contract, who proposed the deal, is now bound by a contract. He cannot leave it. But can the person who has accepted leave the contract? Yes, he can. So when will he be bound? He will be bound when the letter reaches to the proposer and it is read to him and comes to his knowledge. Fair? Now let's move ahead. Thus, the provision makes no difference in position of the offerer, The offerer is bound when a properly addressed and adequately stamped letter of acceptance is posted, something that we just talked about. The acceptor does not become bound by merely posting his acceptance. He becomes bound only when his acceptance comes to the knowledge of the proposer. The contract is concluded at the place from where the proposal is accepted and communication of acceptance is dispatched. The address at which the proposal was sent. The court at the place would have the jurisdiction to entertain a cause of action under the contract. This rule that the communication of an acceptance is complete as against the proposer when the letter is posted is probably intended to apply only when the parties are at distance or communicating by post. Fair. Where, however, the parties are in each other's presence or though separated in space, they are in direct communication, as for example by telephone. No contract will arise until the offerer receives the notification of acceptance. So there are some proper layered ideas of law. We've understood how is acceptance and what is acceptance and how is it working for different people. Now, when does a contract finish? A contract finishes, or in terms is concluded. What we will call in this passage concluded contract is concluded when acceptor posts his acceptance and is read by the proposer. So, wherever the proposer is from, or wherever the proposer is, at that particular location, we will consider the contract to have ended. In terms of